Um, this matter comes on for the full commission today, for permit RR4934931 BSL Entertainment LLC. This was originally initiated as a request by Drew Wignall, the agency prosecutor, for a revocation hearing. The commission also received motion in opposition for request for revocation hearing from Clark Kirkman, attorney for the permittee. So the commission set this for a hearing on those motions to determine the appropriateness of emergency proceedings. Preliminarily, do we have an appearance on file for you?
So,
Okay, I think you could get us an appearance. I think that is required by rule.
okay.
Beyond that, I think we'll have each side present a statement on their motion, justifying their motion. We'll start with the prosecutor since the request initiated with you. Mr. Kirkman, you'll have time to respond based on your motion, and then maybe final response from you if there's anything new that's arisen during that. I know I have questions for both of you after reviewing the motion, so after you present your statement, the commission will likely have questions about where we go from here. And I will note, this is not substantive on the violations. It is about the emergency proceedings. All right, Mr. Rignall?
All right, thank you. I recognize it's not a customary request that I make for the commission, that lead to questions from all involved, both the committee and the commission itself. Although it's not unprecedented, recently the commission did hear a similar request back on September the 23rd of this year. Application hearing under IC 7.1-3-23-12. It's for a permit here in Marion County as well. Similar to that, excise had conducted an investigation. Violation was served, report was submitted to myself rather than proceed through the typical process of Rule 37 with the violation, requested a revocation hearing, and it was set within 3 business days of my request, when the order was issued. The hearing was set for 3 business days. Obviously, I don't make these requests lightly. We have thousands of permits across the state of Indiana. We've got hundreds of violations that come through. It was a calculated move to request this hearing because I felt it was an issue of utmost importance for the commission. Clearly understand the due process concerns that the permittee raised in their motion or their motion in opposition, I guess. But what I would state is that just because I make a request doesn't mean the commission has to grant it, first of all. Just because there's a statute that says it has to be set within or closer than 3 days, doesn't mean it has to be 3 days. It can be a week, it can be a month, it can be however long the commission decides to set it for. There could be requests for scheduling orders, there could be requests for motions to be filed by the commission. So there's built-in due process that can be handled here if the hearing is ever set. Additionally, with our last hearing that was set for revocation, there was in the commission's order, it specifically stated that a request could be made for a continuance if there was good cause and in written fashion. So that exists for the permittee as well. If they feel like they are not ready. There are issues with evidence collection on my end. There's issues with witness availability on both sides. There's issues with making sure discovery is complete. I understand that. We would have concern with that ourselves. So I believe all of that is built in to protect due process. Clearly, Chapter 23 of Indiana Code 7.1 was written for the consideration of when and how to deny, suspend, or revoke permits. That's how it is titled. It lists when the commission may find, suspend, or revoke a permit. It gives a procedure to do so. Recognize again that this is not a customary request that I made. but that statute has no references to Rule 37. It refers only to revocation hearings, not violation proceedings, and that's why it was filed under that statute. So I guess that'd be my big salvo, why it was filed and my reasonings behind it.
I have a couple questions.
Of course.
And the other commissioners may as well. Is there a notice of violation and settlement that was sent on this matter to this point?
No.
So in your opinion, does a revocation hearing require that violations be filed at all?
The statute is not clear on that. To be clear on my end, it just states that the commission may fine, suspend, or revoke permit or certificate for the violation of provision of 7.1 or rule or regulation of the commission. Doesn't address how that should be found to be a violation, whether that is at a revocation hearing or through Rule 37.
So in one of the sections that was pointed out in the motions, I see 7.1323.6, the final sentence states, unless otherwise provided in this title, all further procedures with reference to the revocation of a permit shall be prescribed by rule or regulation of the commission. There are two phrases in here that I'm trying to wrap my head around. The first is unless otherwise provided in this title. And then the other one is all further procedures. So I guess first, in your opinion, what is the unless otherwise provided in this title?
Good question. I can't read into what the legislature was deciding when they wrote that. I can't imagine when they wrote Chapter 23, they envisioned that every single minute detail, every single possible proceeding for the commission had to be drafted in a rule. I think my statement earlier is that all due process would be handled through the revocation hearing as it would any other hearing before the commission. So.
And on the all further procedures, any thoughts on what further procedures means? What was before the procedure they're referencing and what are the further procedures that sentence is referencing?
I wish I knew that. I do not. Be fair.
Commissioners?
I don't have any questions. I don't know. Mr. Wiggle on any questions? Opinions?
Yeah, just have the same questions about 7.1323.6 about the sections, unless otherwise provided in this title and all further procedures. Just when they have weight in the statute, they're there for a reason. Guess I'm just wondering what they mean while they're there. It doesn't say shall prescribe by rules and regulations. There is other language in the statute.
Yeah. All right, Mr. Kirkman?
Sure. There's just a couple statutes in here that to make it handy, a couple cases that I won't really go over in depth, but just for your edification.
Is it your intention to go through these or should we read them?
I'm going to reference them. It's really more to take with you.
Okay.
Well, thanks for giving me the opportunity to present on this motion. My name's Clark Kirkman with Clark Quinn Law on behalf of BSL Entertainment LLC, doing business as the patron saint. Just a little frame of reference. The Patron Saints, an establishment located in South Meridian in Indianapolis. They've been open for about 8 years. Prior to September of this year, they had received one notice of violation before that for a floor plan alteration a few years ago. They're internationally renowned for their house music shows, and people actually travel from all over the country and some international to attend shows there. They've had up-and-coming acts that now are playing at Coachella. Excise recently completed an incident report as EX 25-003422, which was tendered to Prosecutor Wignall on October the 9th, 2025. And then 5 days later, he requested that the ATC hear as a full commission snap revocation hearing at the earliest possible date. The authority, and we've already gone over this, the authority cited in that is IC 7.1-3-23-6. This request was made without an opportunity for a settlement, without an opportunity for a pre-hearing conference or discovery as prescribed by 905 IAC Rule 37. So, notwithstanding what Prosecutor Wignall just presented about due process and opportunity for discovery. The request itself seemed to be an independent, treating Section 6 as an independent vehicle to revoke a permit outside the scope of the procedural rules promulgated by the Alcohol and Tobacco Commission. These rules have been followed for years, and they've resulted many times over in the revocation of a permit. I'll note that IC 7.1-2-3-9 gives the commission discretionary authority to issue, deny, suspend, revoke, or renew all permits authorized by this title, quote, unless the exercise of discretion or authority is limited by applicable provisions of this title. Then we have 7.1-3-23-5, which provides that a permit revocation is only for violations or refusal to comply with Title 7.1. And of course, the following section talks about procedures for revoking a license. That section says the permittee must be given at least 3 days notice. It also says that all further procedures with reference to revocation of a permit shall be prescribed by rule or regulation of the commission. And to answer the question that Chair Allen posed, I think that the all further procedures is beyond the note in the statement in that statute that you have to have at least 3 days. The further procedures are the rules that the legislature is directing the commission to promulgate. Moreover, 7.1-3-23-8, that is specific, that's revocation specifically regarding a retailer permit, which provides that the revocation of a retailer permit shall be conducted in a manner prescribed by Section 6. So to be clear, these are the statutes that Section 5, Section 6, Section 8 that give the commission the authority to revoke licenses. That's what the commission relies on when it revokes a license. Whenever a license has been revoked due to notices of violation, the settlement offers in Rule 37 have been followed. These provisions of law have provided the authority to do so. In fact, if you look at Rule 37 in the code, the commission has noted IC 7.1-3-23 as the authority for the promulgation of those provisions of rule. So Rule 37 are the rules called for in Section 6. And my basic contention is that the commission cannot pick and choose when the rules apply and when they don't apply. So what I would say is revoking a license needs to be done in accordance with Rule 37 and the proceeding with the prosecutor's request, not following the commission's rules, would be a violation of those rules and my client's due process rights. There's obviously good reason to have procedural safeguards in place before revocation, as it's a drastic action that would end a business. That's the livelihood, not just for the owners of the business, but for their employees as well. There's perhaps millions of dollars on the line here. It's therefore understandable that the General Assembly directed the AGC to promulgate rules governing these proceedings. Here, my clients have had no opportunity to speak with Prosecutor Wignall about why, there's not an ongoing issue or to discuss settlement or other issues. It's an axiom of statute, the rules of statutory construction, that to apply the plain and ordinary meaning of clear and unambiguous statutory language. The best evidence of the intent of the legislature is the statute's text. Well, I would say that the language, all further procedures with reference to the revocation of a permit shall be prescribed by rule and regulation of the commission is not ambiguous, and that the plain and ordinary language commands the commission to promulgate procedural rules governing the revocation of a license. And it did. They're found in Rule 37. Moreover, the phrase that unless otherwise provided in its title does not, I would say that does not change the calculus. The phrase, I would say, is a catch-all to harmonize the code. And one example, and maybe the reason for the language, is if you look at, and this is not in your binder, I apologize, but there's special revocation language in IC 7.1-3-23-2B, which directs the commission to revoke a permit for violations of certain statutes criminalizing illegal gambling. So in that subsection, the legislature uses shall. So for all we know, that unless language could be a reference to, well, if you're revoking under 2B, or if you're revoking under 12, like it sounds like Prosecutor Wignall pursued in September, which was a different revocation proceeding for cessation of qualifications, then of course, then you wouldn't need to follow Rule 37 in those cases, but otherwise you need to follow the rules that have been promulgated. I would say even if the commission finds that the unless language is ambiguous, there's a principle governing the rule of lenity that that should cut in the permittee's favor. I know that's criminal doctrine, but I think it would apply here, that if in an ambiguity in the statute should apply in the defendant's favor. I'll also note that Rule 37 plainly contemplates that a hearing judge is not the full commission. For instance, 905 IAC 1-37-12 and the following section, section 13, they make those, without belaboring the statutory text, that talks about the hearing judge prepares the proposed order, tenders the proposed order to the full commission for consideration. It's another reason why this request, not following Rule 37, is without legal authority. 905 IAC 1-37-4 governs the procedures in the procedural safeguards. It says the hearing judge shall give all parties full opportunity to file pleadings, motions, objections, submit offers of settlement by the date of the pre-hearing conference. Also just note that to the extent that Section 5 talks about, may hold a pre-hearing conference, I would suggest that the may language is just, if both parties don't want a pre-hearing conference, then you don't have to hold a pre-hearing conference. Just a couple more things. As far as due process protections goes, the Indiana Court of Appeals has stated that in order to comply with the requirements of due process, the hearing granted by an administrative body must be a full and fair one before an impartial officer, board, or body free of bias, hostility, or prejudgment. That is Guido v. City of Marion in 1972. There's obviously a number of other such cases. I would just respectfully suggest that holding a snap hearing to revoke a license without a pre-hearing conference, without being a chance to discuss settlement, would be in violation of those due process protections. That doesn't mean that the prosecutor cannot ask for a certain timeline at the pre-hearing conference. He's free to do so in a manner that complies with Rule 37. And as I asserted in the motion, there are real due process concerns here because the snap hearing would govern the facts on judicial review. I see 4-21.5-2-6 provides that judicial review of disputed issues of fact must be confined to agency record for the agency actions supplemented by additional evidence taken under section 12 of this chapter. Now that section 12 talks about, the avoidance of unlawfulness, the procedure of the decision-making process. That's section 12 kind of talking about what this hearing is about today. Except for that basis, though, we would have very little time to prepare our case and create a record that the judge would be forced to consider. I would also I'll wrap up, but the commission could conceivably promulgate a new set of rules governing emergency revocations. Those rules would hopefully lay out the parameters for when to seek such revocation. They'd have standards that would apply. They would contemplate processes. They would provide guidance as to how to review the decisions. And most importantly, they would have gone through notice and comment so that they can be tested and we can come up with something workable. Here, though, that hasn't happened. So what we're left with invoking the most drastic possible penalty without rules, without procedures, without standards. If we're not going under Rule 37, then what is the different basis for this procedure? Is it a lower standard? What happens if we are successful at the revocation hearing? Does that dispatch with the notice of violation that was issued? I'm not sure, but I'll just wrap up with respectfully requesting that the commission deny the prosecutor's request to set this matter for a snap revocation hearing that does not follow the precedent of Rule 37. We are ready to meet with Prosecutor Wignall to discuss the violations, explain the current operations, hopefully settle the matter. Barring settlement, we ask that the matter proceed in accordance with Rule 37.
Thank you. I do have some questions, some of them similar to what I asked Prosecutor Wignall. Does a revocation hearing require that violations be filed?
As it pertains to this type of revocation, yes, because that section 5 says you can revoke on violations of 7.1.
Could the commission become aware of a potential violation and set a hearing?
Would the commission become aware and set a hearing? So outside the scope of the prosecutors?
Yes.
I think when it comes to cessation of qualifications or something like that, that would be more appropriate. If it's a notice of violation, I think the appropriate, what I would consider to be the way to handle it would be to refer that matter to the prosecutor.
So in 905 IAC 137.7A, it says that hearing judge shall give at least 5 days notice of the hearing. And then it goes on to say the hearing judge, well, the sentence before that says the hearing judge shall set the time and place of the violation hearing and give reasonable written notice to all parties. The hearing judge shall give at least 5 days notice of the hearing. So in one sentence, it's saying reasonable notice, then in the next, it's saying 5 days. Is this indicating that 5 days is reasonable notice?
Well, first I would say that, that 5 days would be following a pre-hearing conference. So it wouldn't be 5 days from a notice of violation. Now, can we, how the timeline could play out, that's for anyone's guess. But I would also note that, it used to be 10 days in the section 6, right? And so it's 10 days. It was 5 in the rule. I don't believe that the rule's been updated since the statutory text was changed. I don't know, they thought that it would be at least 5 days that it would take to get the pre-hearing conference. But I would say that the 5 days is, you need at least 5 days notice of the hearing coming out of the pre-hearing conference.
So not talking about the facts of this case, so talking in like a hypothetical, but if a permit holder is issued a violation for, say, sales to minors and refuses to stop selling to minors and says, no, I have to have time to file motions and do discovery, and you can't revoke my permit until I have that time, but they are actively telling us and actively Friday and Saturday night selling to minors. Is it your position that the commission is without any recourse to address that until we go through everything in Rule 37?
Say that all cases are different. And there is the ability within Rule 37 to move swiftly. But Rule 37 needs to be followed.
So we would have weekends where we just know a bar would operate in violation of law.
I mean, excise can show up at a bar and it's not like they just throw the Indiana State Excise Police out. They continue operating, right? I mean, bars get cleared out all the time.
So you're saying, I guess now I'm trying to wrap my head around the difference between excise shutting them down, it sounds like, and a revocation or a suspension without Rule 37.
Well, I'm talking about like clearing the bar for an evening. We know as just a general matter, the commission does not have emergency authority to suspend a license. I would think that any permittee, I wouldn't think a permittee would be thumbing their nose like that because they know that they would be, on the chopping block. I'm sure the commission would look askance at them potentially selling their license and being able to recoup their investment on that. I mean, there's just a whole host of reasons why, as a practical matter, hopefully that would not happen.
But if it did, she's asking what would happen.
I mean, I am using like an extreme example here, but to say that the commission has no ability to quickly
Well, the thing about
revoke a permit.
I feel like, I believe that there is actually a statute in here about revoking a permit for repeatedly selling to minors. I have to thumb through it though.
There's one about selling to minors after parents have provided written notice to not admit a minor to a bar. I'm not sure I've seen that fact pattern since I've been here, but.
And there's always the commission acting and then your problem bar taking it up on judicial review and seeing what the judge says, looking at the facts in place there. I mean, we're not talking about the facts of this case. My clients are not those types of bar owners.
And one of the things you were indicating, are you saying that because Rule 37 contemplates a hearing judge, the full commission could not sit and hear a matter under Rule 37, or did I misunderstand?
No, that's what I think the rules as they're written call for a hearing judge to sit and to prepare an order and then present that to the commission. I mean, that's just what the claim letter of the law says.
How does that work with the statutes that were passed subsequent to this, when they adopted the Office of Administrative Law Professionals and required that now either the commission or a member of the commission sit.
I would have to look at, the interplay there. But I don't have an answer for that. I just know, I'm just talking about the rules are the rules. If the commission wanted to amend its rules to account for the law change, I suppose it's free to do so.
But this rule would trump anything that might be in that statute.
My basic intention is that the rules were promulgated under section 6, which governs revocations. Those are the rules that the commission wrote at as directed by the General Assembly. And when you have rules on the books, they have to, you can't decide, well, we're not going to follow our procedural rules for this case. We're going to do something different. That's my basic premise, my basic point.
Other questions?
How would we not be following the rules if we proceeded as the prosecutors requested? How would we not be following the specified rules?
Well, based on, first of all, what I said about, I do believe that this matter should be heard by a hearing judge and not the full commission, as the rule dictates.
What rule dictates that?
Well, if you look at section 12, I believe, and 13, it says the hearing judge presents the proposed order to the full commission for up or down vote.
But 7.1234 says the commission shall have the power to hold hearings before the commission or its representative.
7.1-2-3-4.
Yes, sir.
So that, I believe that is a reference to when the commission used to have the executive secretary hear matters. And so that, as Chair Allen indicated, that statute with since the OALP statutes have said, probably not even, doesn't continue to carry full force of law, because you can't, it's only the commission now and not the representative now. The way the Rule 37 is,
Okay, well, let's wipe out or its representative can hold hearings before the commission. Doesn't limit it to a commissioner.
well,
Your brief says it has to be in front of a commissioner. I don't find any place in the law where it says that. Please point that out.
it does in the rules and
Where
rules.
does it say that? It references hearing judges, but it doesn't say only one person can act as a hearing judge, does it?
I guess it would not follow logically that the full commission would present an order to itself.
So a hearing judge can only mean one person in your estimation. So the commission's without power, let me interrupt myself. So when can the full commission hear anything?
Well, it has the general powers to hear, this hearing right now is under the general powers of the Alcohol and Tobacco Commission. I don't have any problem with the hearing that we're sitting at right now. I don't think there's anything procedurally irregular about it. But my basic point is, if the hearing concerns a violation of Title 7.1 and revocation is on the table, and the statute cited is 7.1-3-23-6, the legislature said you got to promulgate rules to follow when you revoke a license for a violation, and the commission promulgated those rules. It's Rule 37. Now,
But I'm gonna interrupt you there. You keep overlooking unless otherwise provided, and you blow that off as meaningless. But doesn't unless otherwise provided mean unless somewhere else in this title,
Yeah, like,
there are procedures that can be followed. You need to promulgate rules, but if those potential rules are already covered somewhere else in the title, you don't, excuse me, you don't need to promulgate.
well, I don't blow it off. What I was saying was, unless otherwise provided in the title, could be section, IAC, 7.1-3-23-12, revocation for cessation of qualifications. Or 7.1-3-23-2B, revocation because of violations of these gambling laws. That's what unless otherwise provided. Otherwise, I think the inverse is that you must promulgate rules would be rendered a nullity. It wouldn't have any meaning. They wouldn't write that and then not have to promulgate rules to hear violations. But what I would also just return to is, Prosecutor Wignall in his presentation talked about, we can do discovery, we can have, we can talk settlement. I'm not sure if he said settlement, but we can do all these things, these procedural, have these, ask for continuances. And I guess at a certain point, I'm not seeing the difference between the request for a hearing that he has made and simply following the rules. So why don't we just follow the rules?
This is Chris Sarek, Executive Secretary. I just wanted to make a record. The Executive Secretary is here. And I'm going to refrain from pontificating on the procedure at this time, but I may have a written analysis for the commission in the between now and the next time this matter convenes. But I just wanted to make a record that I am here.
Okay, thank you. So I guess if there's time for discovery and settlement, is the request for revocation significantly different than if notice of violation and settlement requesting revocation was sent?
I don't know. Because one question I raised in my presentation is, so we hold a revocation hearing. Presumably, we have to have a chance of prevailing at the revocation hearing. If we do prevail, what's the outcome? Is the commission free to then decide to suspend the permit for 3 days and issue a $2,000 fine? And so I guess I don't understand why we're not just proceeding with issuing notice of violation, scheduling talking settlement, scheduling pre-hearing conference. I don't understand why that's literally the reason why I wrote the motion in the first place, is why are we proceeding with this novel approach when we have rules, when we have standards, when we have precedent? If we're going to allow for discovery and continuances, and but I don't know what is all that different, other than I don't know what the standards we're applying are and what the potential outcomes are.
Are you there with the question?
Go ahead, go ahead.
So, a couple of terms Archie used, but you used the term snap revocation. What is that? Is that
Well,
a term of art, or is that just a descriptive of quickly?
It's a description for quickly, yes.
So there is no definition of snap.
Correct, but
Okay.
the request that was made was at the earliest possible date, 3 days. That to me is within the definition of the general definition of snap.
Okay, I've never heard that before, that's why I asked. snap?
Well, this is a new request, type of hearing.
I'm just trying to clarify. Secondly, you use the term very little time. What is very little time? What's a right time and what's a long time?
Where did I use that? Sorry.
I just wrote it down when you said it. You were talking about how things are held, how long they will take, discovery and all of that. What is your definition of a very little time to answer and respond?
Oh, well,
3 days, 5 days, 10 days, weeks?
I mean, it would depend on the circumstances of the case.
I don't think it does depend on the circumstances. I think the definition of very little time should be specific. In your mind, it's a fluid time. Doesn't matter.
Well, I guess that's one of the procedural safeguards of Rule 37, and why I'm asking that we follow Rule 37 is because it gives we all understand, how that goes. The procedural timeline, like I indicated, I believe if Prosecutor Wignall wants to ask for an aggressive timeline, like he is free to do that, and both sides can talk with the hearing judge about what that timeline should be, and it can be decided upon.
You just add another phrase, aggressive time frame. Yeah, you have no time limit for that, just it's in the eye of the beholder then. Right?
Well, one of my general points is we're being asked to participate in a hearing where I'm not sure what the rules are. So, I'm talking about timeframes, but because there's nothing to define how long things should take other than the 3 days, which in my judgment would be a very short timeline and could result in a factual record that would be problematic on judicial review.
Well, all of that, counsel, goes to 7.13.2036, which states commission shall give at least 3 business days. I don't know if you would consider that a very long time, an aggressive time, a short time, but the legislature said very clearly, 3 days is all you need to give, right?
It said that. It also said that they needed to promulgate rules. And the ATC did that. And those rules call for things like a pre-hearing conference prior to a hearing.
So the 3-day conference or the pre-trial conference could happen on the 4th day. Because it says at least 3 business days to the holder of the proposed revocation. It anticipates you can't hear it within that 3-day period, but you can hear it any time after that. Is that correct?
I indicated, I agreed that the timeline doesn't have to be, very long, a very long time frame. I'm trying to start going here.
No, I know you are, because it says 3 days. And to me, that's kind of the standard then. That's, you go after that. You can't go before that. But you can do it the day after that, because at least 3 days, right?
So if we're working under the rules that were promulgated in accordance with the legislature's, direction, they need to, it calls for discovery, calls for, all these things that lead up to the hearing date itself. And so, are there ways in which it could be a quick time frame? Sure, but we have not received a violation yet. We receive a request for a revocation here. So.
And you're entitled to 3 days notice, at least, and then it can be heard. And that anticipates then within that 3-day period of time, there is time for discovery, time to get everything done. And so again, you use the term snap revocation, that I heard very little time, that I heard aggressive time. 3 days is unusual.
Yes.
And you'll agree to that.
3 days is unusual, and you know, the commission is, I mean, due process requires that the commission should be unbiased and not prejudge a matter. So, you know, as far as the hearing judge scheduling, you know, getting a notice of violation or getting some sort of request and then scheduling it for 3 days out, to me, that could be an indication of a prejudgment there. I mean, there could be good reason for it. I mean, you know, such as what the Chair Allen's hypothetical. You know, we have people that, you know, that they sold the minors 3 weekends in a row. We don't think we need a whole lot of time here. We need 3 days. And let's schedule a pre-hearing conference quick and move forward. But one contention I have is like, that is not the facts this matter. We're not talking about the facts today, but
I've got 2 more points. I'll be quick. The issue is not prejudgment. The issue is the determination that this is serious and requires, in essence, emergency consideration. That is different than prejudging the facts in the conclusion. 2 more things. You mentioned the term clearing the bar. What does that mean? You said excise has the right to clear a bar.
well, I mean, if excise shows up and notices violations of the alcoholic beverage laws, I don't think that the bar generally continues to operate that day. I think most of the time the bar clears out pretty quick.
Assuming that excise does have the authority, which I think you just said, that they have the authority to clear a bar, could they clear a bar?
I'm talking more as a practical matter.
I'm not sure. Impractical is the opposite? I don't know what you mean by practical.
As a practical matter, when excise shows up at a bar and identifies certain violations of the alcoholic beverage laws, generally that bar does not continue to operate that day.
I mean, of their own accord.
Of their,
So you don't think excise has the right to quote clear a bar?
I mean, under the general police powers, sure, yes.
Could they, assuming that, could they go back Friday night and clear the bar, and Saturday night and clear the bar, and Sunday night and clear the bar? In other words, is the right to clear a bar unlimited?
No, I would not say that. I mean, we're getting a little, I mean, first of all, I'm talking about if there are serious violations present at that time. I mean, they can't just show up somewhere and clear a place out if there's nothing improper happening.
This goes to the chair question about minors being served inappropriately over and over again. Assuming that that happens, could excise clear the bar over and over again?
There are minors there, then certainly they have police authorities to take action.
Clear the bar.
I'm not in charge of the Indiana State Excise Police.
Okay. Thank you. I have no further questions.
All right, on the timing, there's been a lot of talk about these different phrases. But specifically to this, what additional time do you see? Well, I guess first, your client did receive the excise notice of violations,
They
correct?
received
Or
the green tickets,
Okay.
but we have not received any notification from the prosecutor. That normally, my understanding is that it's not really a notice of violation until Drew serves it. Because, you know, Drew reviews the citations written by the Indiana State Excise Police, and he determines what violations move forward. That's his job.
So they've received a notice of violation, but the question remains whether or not.
We received a citation. Citation from the Indiana State Excise Police.
So they received notice that there's no alleged violation that occurred, correct?
Yes.
So what you're talking about is Mr. Wignall's consideration as to whether he's gonna push the matter forward further, correct?
Correct. Now, I'm not arguing that he's not doing so, but, I mean, the way this system usually works is, you know, we receive a notice of violation and it's, you know, it's tendered to the client, to the business, it's potentially tendered to counsel if counsel's working with a business. And we schedule a settlement conference and, you know, we talk about what happened and what changes potentially have been made at the business. Other relevant factors. And if we, you know, can't decide which way to move forward, then a pre-hearing conference gets scheduled. And I think that, you know, Prosecutor Wignall would be well within his rights to say, you know, to meet once and say, sorry, I'm asking for pre-hearing conference. I don't think that I think that that's perfectly appropriate. And in fact, I think I said in my motion, you know, in the alternative to treat this as that.
Well, you and I clearly disagree as to whether a pre-hearing is required. I understand there's different language that a hearing judge may hold pre-hearing conference. But that certainly in statutory language doesn't say he may hold it if one of the parties wants it, but he doesn't need to hold it if one of the parties doesn't want it. It just clearly says the hearing judge may hold it. So what you don't like, I get the revocation possibility. So what in your mind would give your clients due process as far as the timeline's concerned?
I mean, I would like, you know, certainly the time necessary to prepare a case as I would otherwise do. You know, I don't want to put a time certain on it. I'd like the opportunity to review and, I mean, first I'd like the opportunity to just meet with Prosecutor Wignall and see, you know, understand, hear his concerns and, you know, try and move forward from there.
Have you attempted to meet with Prosecutor Wignall on this matter before today's hearing?
I mean, so
So you asked me a question.
we've briefly spoken about it, yes. And we have talked about, you know, getting together with my clients. And then as soon, you know, then this got scheduled and I didn't think that, you know, it was the appropriate time to meet prior to this hearing. But I actually asked Prosecutor Wignall before the hearing if we could get together immediately following so we could maybe find some time on the schedule with his calendar.
So I guess that gets back to the timing question on all of this. I think we're still talking in generalities and we haven't really gotten down to what permits he thinks would be appropriate for due process and not. So I've heard you want to meet as a group with your client and the prosecutor. How much additional time would you need for discovery? And before you answer, and I'm gonna ask Prosecutor Wignall the same thing on his discovery that he would seek in this. In matters here, I'm guided by the general purpose of Title 7.1. And the first one is to protect the economic welfare, health, peace, and morals of the people of this state. When we're dealing with allegations, and I'll say they're allegations, we haven't heard them, I haven't seen reports, but violations that were noticed in citations are serious. So I would ask both parties to keep that in mind, that if we're attempting to protect the welfare, health, peace, and morals of the state, as well as economic welfare, I think it's in everyone's best interest to decide this matter in a timely fashion, regardless of what path we go down. So with that statement, now I'll ask the question again and allow both sides to answer. What time would you need for discovery?
I would probably want to file public records requests with IMPD, and that can take some time to get a response back. Sometimes it takes a month. So,
Have you, so you've known about the citations from excise. Have you attempted any of that public records requests before today?
sorry.
Prosecutor, what additional time do you anticipate needing for discovery?
From a T or on my end?
Well, both.
Okay.
I mean, you would also have the right to seek discovery of business records, and certain items if.
And I anticipate needing that, and I think I could be ready in a week.
To send out discovery or,
Yes.
okay.
I will say also, it's possible I would want to, do some depositions of, witnesses that are identified on a potential, I assume that I would get a witness list from Prosecutor Wignall, what witnesses he might want to call, whether I want to depose any of them prior, so I know what they intend to say. Commissioner Jones, one thing you said, I know that in section 5 of Rule 37, it talks about may hold a pre-hearing conference. Like I did previously reference, in 905 IAC 1-37-4A says the hearing judge shall give all parties full opportunity to file pleadings, motions, and objections and submit offers of settlement by the date of the pre-hearing conference. So I guess I respectfully would read that as indicating that, we should be entitled to a pre-hearing conference in a matter such as this, that's held under Rule 37. And that to the extent that Section 5 says may hold a pre-hearing conference, if neither side wants a pre-hearing conference, then I guess we don't have to hold one, but if we feel that it's,
Part of the argument is you can't ignore statutory language. Part of your argument is you can't ignore statutory language, and you're asking me to ignore the language that says may hold. Legislature, in your words, your implication is legislature didn't know the meaning. So
these are rules. These aren't these are promulgated by the ATC. They're not, written by the General Assembly, but it uses the word shall in 905 IAC 1-37-4A, talking about the pre-hearing conference.
does say shall hold a pre-hearing conference, right? It says shall allow these things, so we could still allow you to do all those things. Just wouldn't have to have a pre-hearing conference, correct?
I read by the date of the pre-hearing conference, meaning that a pre-hearing conference should be scheduled.
But you've also indicated that today could be the pre-hearing conference.
Today? I don't think I said that. This is an oral argument on that it's scheduled on a hearing on motions.
Wasn't that your statement, or alternatively?
I said to treat Prosecutor Wignall's request as a request to hold a pre-hearing conference.
So if we decide to treat it as a request for pre-hearing conference, and we decide today's the pre-hearing conference, that suffices for you?
That's not how I was preparing to appear today. Again, I think that it still should be handled under Rule 37 with a hearing judge, and that full commission is not the hearing judge.
So what should the rules look like? If you're saying we should promulgate more rules, what do those look like?
But like I said, I think that there would be criteria for when to seek an emergency revocation hearing, a hearing on this timeline that's not in accordance with Rule 37. I mean, if the commission were writing a new set of rules, it would be for this type, for a situation such as what Prosecutor Wignall is seeking here. This is an aggressive timeline revocation hearing.
So what would that look like?
I think we would define, when those types of hearing, when to proceed under those rules versus Rule 37. What, the burdens are to show what the potential outcomes are, what, how those would be reviewed, and, any procedure, the rules of evidence,
Wouldn't the rules be the same as far as evidence is concerned and other procedural things that we already have written? I understand your concern about what arguably in a criminal sense at least would be called double jeopardy. I understand what you're talking about is if you prevail at a hearing on revocation, then what happens?
Yeah.
I mean, there are arguably legal theories that would cover that without it being the rule, but I understand some of your concerns, small ones. While I don't understand some of your other concerns. But I guess I'm trying to give you a wish list. So what does that look like? I mean, how do you, so you want the legislature to limit us to specific issues in which we could ask for this kind of a hearing, even though we're given broad discretion as to when we ask for revocation or suspension, you want only specific instances to be allowed. Is that what I understand?
No, that's not what I'm saying. What I'm saying is the authority that the commission may use to revoke a license is under Section 6 of Chapter 23. And that statute asks the commission to write rules when it seeks revocation. Before it revokes a permit, and to follow those rules. It's written rules, they're in the administrative code under Rule 37. My contention is you could potentially write a new set of rules that deviate from Rule 37 and the procedural safeguards there, but there would have to be a basis for writing those rules and when to use them. And we don't have that here today. Right now, all we have is Rule 37.
Under 6, the language is notice to the holder of the permit proposed to be revoked. You've got that with the prosecutor filing his notice to propose, request, consideration for revocation. And under the statute, 6, 3 days, can't hear it for 3 days, but we can hear it on the 4th day. What does that say to you about your concern of procedural safeguards, discovery and everything? To me, it says you have to get everything done within the 4th day.
It also asks that the commission promulgate rules. Yeah, we're just kind of going. And it did, and I'm just asking that we follow the rules that have been promulgated. I mean, it's really that simple. my position.
Other questions?
I don't know.
No, ma'am.
No,
I think for discussion here, and I'm just throwing this out.
I'm sorry to interrupt, but I think you indicated to Mr. Wiggin we'd have a chance to respond.
Oh, I did.
I don't think he's been given that opportunity.
Thank you.
You're welcome.
Mr. Whitmore?
Well, I appreciate that. I'll be very brief because we've gone on here. As Mr. Kirkman said, we're kind of going in circles, I think, but there's a comment made by Mr. Kirkman about this is how the system usually works, referring to violation proceedings. Well, there's an argument to be made that that system isn't currently working very well. So that's why we're here today, and that's why I made this request. I chose not to proceed with it as a violation under Rule 37. I chose to file under Chapter 23, Indiana Code, 7.130, 7.1, 323. So, the commission does not have authority for emergency suspension or revocation, and that's why I'm requesting a hearing to be held to determine that. Whether or not facts here would fit the extreme of seeking revocation. As I mentioned at the beginning, this is not something that I presented willy-nilly. It's not something I do very often. It's something I felt that was needed in this situation. And I feel like Indiana Code covers it. As someone mentioned up here, the commission does have, the general power to hold hearings and take testimony and receive evidence. It's something that the commission is allowed to do. They've had evidentiary hearings of all kinds in my 4 years here. So I don't believe this would be outside the norm. So.
Any questions for Mr. Whitmore on that?
None here.
no,
All right. For purposes of discussion, I don't totally disagree with the comment just made that maybe the system isn't working and that's why we're trying something different. I think there was a change by the General Assembly from 10 days to 3 days, seeming to indicate move faster on certain circumstances. However, we've heard that the prosecutor would be doing discovery potentially. So then maybe we don't have to address the 3-day issue today, and whether 3 days would give due process, because it sounds like both sides would be seeking more time than 3 days in this situation. I know that punts it down the road some, but I'm leery of foreclosing the 3-day option if the, health, safety, and morals of the citizens of Indiana need us to act in 3 days.
there for a reason. We were given the authority for some reason.
I look at this as an interpretation, the Hamiltonian or Jeffersonian interpretation of the Constitution, and by virtue of that, the statutes. And I think the legislator has spoken very clearly, move some case along. It doesn't say all cases. In this case, the prosecutor has looked at the information available at the time that he reviewed it and decided not to do the violation, decided to do the revocation. It's the commission's responsibility to make a decision on whether that's an appropriate remedy. And I think the commission should decide that this is serious enough, not through a hearing judge, not through a long drawn out process. In the civil actions, there are many cases where an emergency restraining order is granted. And it's called an emergency restraining order for a reason. There are some circumstances that are so calling for action, immediate action, whether that's snap, very little or aggressive, that call for action, and the prosecutor has chosen this route. It's up for us then to determine, consistent with, I think, what you've accurately stated, the legislative intent of ATC is to protect the health and welfare of its citizens, to look at whether or not this may be one of those cases that should be heard quickly, aggressively, snap, with very little time. And that means very little time for discovery, not in the normal course of events, not as we may normally do, but under a set of circumstances, you gotta move fast. I think this is one of those.
I will say, in trying to prepare for today's hearing, I did try to look at what the commission's precedent is for that emergency statute. I think except for changing it from 10 days to 3 days, that statute has been in place for a while. And there is precedent that the commission has used it, filed, or, sent permittee notice of revocation hearing. It had similar language. The order from the commission had similar language to what Prosecutor Wigmore referenced earlier. Continuance will be granted for good cause shown. And in the case that I was able to find just preparing for this, attorney for the permittee did ask for continuance. In that case, actually, interestingly, a staff attorney at the commission filed and was representing excise in the matter. So they actually had excise involved in the proceedings. So there was the prosecutor, an attorney representing excise, and the permittee's attorney. But it seemed like everybody agreed to the continuance. It was granted. And one of the reasons for the continuance was possible settlement negotiations and additional time to prepare. So I think there is precedent for proceeding under that revocation statute.
I'm a little bit in the question, maybe perplexed is the right word, maybe it's not. I certainly understand and appreciate Mr. Kirkman's at least perceived need for time to do some discovery. I don't know about the seriousness or lack of seriousness necessarily about this particular case, because I didn't think the purpose of this hearing was to weigh the severity of the notice violation, but was rather just on procedural issues of whether this is a legitimate statute and a legitimate proceeding. I glanced at it as I'm sitting here, as Mr. Kirkman provided a copy of it with his motion in opposition, but just a glance. Certainly there are some serious allegations, which cuts both ways, frankly, for both the discovery process for Mr. Kirkman, as well as the ability to garner witnesses and have them come in. But I also acknowledge, as you have, Chair, and you have, Judge, the legislature's desire that in some circumstances we push these things through. On the other hand, I also know that at least if I were sitting here as a judge as opposed to a commissioner, legislature can't interfere with what I think is appropriate judicial response. So like I said, I'm a little bit torn on that. Had this been filed as a motion to continue, or motion for continuance, that might have given me a little bit more information as to why he needed a continuance or what actual discovery was needed to be done. But I don't know, I'm a little bit torn. I disagree with a lot of what is argued today, but I certainly understand as an advocate why Mr. Kirkman's arguing what he's arguing, but I disagree with the final line. That's his right and my right. Disagree on that. I think the statute's pretty clear and the rules are pretty clear that his due process, his client's due process will be protected, and I have faith in us that his due process rights will be protected. I know that's not in the form of a rule or in the form of the statute, but I have no doubt that we would follow the rules generally. Darn, how the chair wants to proceed.
Well, I guess the main matter before us today is can we proceed with a revocation hearing instead of a, traditional or more common notice of violation, which, as I noted, the notice of violation that the prosecutor sends could be notice of violation, and the settlement offer could be revocation. So I guess that's the issue, and just depending on what we decide on that issue, then we would have what's the next step, and ultimately, when do we set the final hearing on the merits, whether it's notice of violation and settlement offer. I would anticipate for revocation, the prosecutor has already indicated that would be likely his ask, or a revocation.
And we also know how negotiations often go, so. That could or could not be. My thought is if we grant Mr. Kirkman's request to not have a revocation hearing based upon his motion, then I think we have essentially, or at least arguably, found the statute to be ineffective, absent the promulgation of more specific rules. I think we have a sufficient basis, as I said, in the statutes and rules as they are, to make sure he's got his due process, but that's my fear if we grant his motion in opposition.
The chair entertained a motion.
I would,
We're gonna need something, right?
yes.
I'm going to move, subject to amendment and modification by other members of the commission, that we deny the motion in opposition to request revocation hearing, determine that, at least for purposes, to be a motion to dismiss the revocation, and that we set this matter for revocation hearing within 10 days, instruct the parties to engage in dialogue and discovery between now and that time, and consider in between that, when the parties have had time to discuss this, whether or not it should be continued further for additional discovery in preparation for the hearing, but leave that to the parties and the prosecutor to decide. Since he moved forward, let the parties decide if the date that we set, and I would suggest 10 days, because the statute says can't hear it for 3 days. It's now been longer than that. I forget what date your motion was filed, but it's been a number of days so far, and 10 days would give us time to look at the calendar of the commission, the calendar of the individual commissioners, and give us a target date to recognize the significance of the legislature's intent by statement that we have to give at least 3 days notice. That's my motion.
Second.
It's been moved and seconded. For further discussion on the motion,
You want to set a pre-hearing conference too? I'm just asking. You said, oh, I'll withdraw the question.
No, I think it's a great question. I would suggest nominate one of the commissioners to serve as a discovery
Pre-hearing judge.
pre-hearing judge to be available at the request of the parties to discuss any matters of discovery and try to resolve those as quickly as possible.
I would second that as amended motion.
I'm going to have to write that out then.
yeah, well,
Chris is off.
I'll be happy to write it out in just a little bit.
I would suggest, and I'm not gonna make this part of the motion, but if the parties do request a continuance and agree to a continuance beyond the 10 days, I would suggest possibly bringing forth a scheduling order. I know we don't typically do those, but they've been on my mind for the purpose of when there's a nuisance allegation pending. Those are our most serious. The sales to intox and the nuisance are the ones we consider the extremes.
Word.
Yeah, and unfortunately, we see those sometimes dragging, so this is just a suggestion, if you do agree to a continuance, to potentially do a scheduling order so that things stay on track, discovery stays on track. There's a path for discovery, not just arguments that, well, the rule says discovery, but there's actually a path of what that discovery looks like and that it's moving.
I will respond only in that I think the legislature has spoken quickly. I would not be in favor. This is not going to be a normal case, in my opinion, that we go, well, for a month or two and wait for everyone to say that it's done. It's gonna be done. I like the phrase, if it's gonna be done, let it be done quickly. If this is gonna be heard, let's hear it quickly. And if the parties don't understand, at least my position, get on this. Drop other things and get on this. We've asked for, prosecutors asked for revocation. We've been asked to consider that, and I think we need to consider that.
We have a motion and a second. The motion says 10 days with a pre-hearing conference. Do we want to be more specific in the motion?
Does it say?
Well, you're gonna get picky now.
No, I.
I think so. Business stands.
Well, 10 days is a Sunday, so,
Then not 10 days.
Okay, so 10 days, how about approximately 10 days?
All right,
Then we can vote on that motion,
Alright.
and then we can talk.
approximately 10 days.
is there a second to the amended
Second.
motion? Okay, there's a second to the amended motion. It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Now we can talk about scheduling. If we look at 10 business days, we're looking at November 20th. Oh, you're right. So we're looking at the 21st, which is a Friday.
You said it, I'll be here.
Commissioners and prosecutor, counsel.
The 21st is open on my calendar.
For the following week too. So we
Just need a
might,
quorum.
yeah, we might proceed with 3 as a quorum.
I will state, having been in touch with some of the potential witnesses in this case who work for IMPD, they both work a late shift. Typically, afternoon settings are best. I don't know if that's something you entertain on a Friday afternoon or not.
I would,
Work all day on Fridays most of the time, so
what day are we talking? Friday the 21st.
Okay. I'm looking here at page 3 of 5 in the notice of violation. Just looking at that page, which talks about police runs. You really think we can get through this case in half a day?
Choose your witnesses wisely. That's my answer.
Or do we set it for the morning and then you arrange witnesses? Suppose those Pine PD officers would be the primary witnesses.
I'll make sure they're here at set at a given time.
Mr. Kirkman? Anticipated witnesses?
We'll have to, work out, I assume some of the employees of the establishment.
Given what you know of the case, how long do you think this would take to trial?
Certainly no longer than a day.
Do you agree?
Yes.
So we can either do full day on the 21st, or we can do half day and half day.
I'm for a full day, I work all day.
Remote. I can be remote, however you want to arrange it.
I'm open all day.
All right,
So then what time?
9 o'clock,
First.
right early. Yes, for me.
All right, then we will show this set at 9 AM, on November 21st. Anticipated no longer than one business day for the hearing. I may have to re-listen to this to be specific, but I'll type up a written, order following today's hearing.
I ask this with great trepidation. Do we want a pre-hearing conference that now, or do you want to want to request it if needed?
I'm gonna set something for next Thursday. Just to get something on the books. But that next Thursday is the auction.
Auctions ones.
Well, I don't have interferes with anything.
The auction's Wednesdays.
Thursday. Thursday too.
We'll do it next Friday.
Friday the 14th.
Yeah, I'm available all day.
I'm happy for one of the commissioners to conduct the discovery pre-hearing.
Just pre-hearing.
My Friday's pretty full.
Okay.
Did you just say Friday is packed for you?
Yeah, I have to be in Hamilton County in the morning, and then my son's giving a talk at school in the afternoon.
Days. What about the 12th?
Or the 17th.
17th in the morning would be fine for me. I have to be in, begin the at a local board hearing at 1, Terre Haute. And on the 14th, around, I'd say 11 AM would be fine on the 14th.
I'm not stuck on the 14th if it's gonna be too tight for you.
I should be fine if the days have been thrown out.
So I guess putting you on the spot, Mr. Kirkman, 14th or 17th.
I would prefer the 14th at 11 because I gotta get to Terre Haute, and that's gonna be important.
14th in the morning?
Well, I was saying 11. So the Hamilton County moved to Friday because of the Veterans Day holiday. So it's on, so I have to get Hamilton County at 9. But it'll wrap by 10 something. And this, you know, the pre-hearing's virtual too.
Yeah, I anticipate this will be virtual.
You want to designate to hear that? Do you want to hear
I can hear
Okay.
it. I'm
I
here on Fridays, so I can hear it.
it? Okay, agreed.
Could I just, I'd just like to make one statement, so the record, well, not even the record, but, yeah, I wrote this motion, and I wrote it kind of when after reviewing certain, I received the request walking out of Animal Kingdom at Disney World. So I was on vacation the entire week. Wrote the motion, with some, urgency, because I wanted to get it on file before, because I was expecting a quick, you know, I didn't know when the commission was going to act on this. One, like one reason, and one reason I wrote it, one reason I, you know, wanted to just hit the pause button a little bit on this is because, again, we have not had a chance to, you know, talk to Prosecutor Wignall. And I am hopeful that in talking to him, we can, you know, get a better understanding of what's going on with the patron saint and, you know, hopefully, you know, come to some sort of resolution in that regard. So I would just request that the, you know, the commission keep an open mind about what might happen coming out of the settlement negotiations and go from there. Like I said at the top, the clients have had a violation some years ago for a floor plan alteration. They otherwise have not had any problems with the Indiana State Accessibilities. These are not the kind of people that are running the.
And I think I'm gonna stop you. We're not at like a substantive hearing yet. I think this is set, while it is set for a revocation hearing, because that's the approach the prosecutor has taken. It's the same approach, from sort of a neutrality standpoint, as if it was a notice of violation, with the prosecutor asking for penalty of revocation.
I just. That's.
I'm not clear of the reason, and I better judgment, I would keep my mouth shut, but you've got two judges here who are experienced, one lawyer and someone who's been here. We're not going to prejudge the allegations, counsel, if that's what you're suggesting, and I think that's what you're suggesting.
I'm just, just, you know, I did include the incident report. We're going over it. So, you know, we was being gone over briefly. I just wanted to that statement and, I know that, the members of the commission are very professional. I know you all, and that's, I didn't mean any disrespect by that statement. Just, I'm still hopeful that we could talk with Prosecutor Wignall and move through this. Maybe that's, you know, maybe
I think certainly settlement negotiations are not foreclosed because this is set for, a revocation hearing.
I'm
At
always
this
open
point.
to parties presenting a settlement offer. I don't care what you call me,
thank you.
Yeah,
opposing parties can agree or not agree.
and you know, the prosecutor brought the motion for revocation hearing. The prosecutor could withdraw the motion for revocation hearing. You know, that's all still open here.
Absolutely. Thank you.
Anything further from the commission?
Thank
Thank you. That concludes our hearing for today.
you.
Thank you.
No.